Hello everyone, I'm Aratra Bhaumik and I welcome you all to another episode of Courts Today on LiveLaw, where we update you about all the important legal developments that took place across the country today. We will begin with developments from the Supreme Court of India and then move on to High Courts and other subordinate courts. If you like our content, then it would mean a lot to us if you could please like and subscribe to our YouTube channel. Let's begin. In a significant development, the Supreme Court of India today stayed the order of the Uttarakhand High Court for the removal of occupants in railway lands in Haldwani, based on which the authorities had issued eviction notices to over 4,000 families who claim that they have been residing in the area for years based on valid documents recognized by government authorities. Taking exception to this High Court direction to remove the occupants in 7 days, the Supreme Court observed with dismay that there cannot be uprooting of 50,000 people in 7 days. A bench comprising Justices Sanjay Kishan Kaul and Abhay Soka passed the order while issuing notice to the state of Uttarakhand and the railways in a batch of special leave petitions filed against the judgment passed by a division bench of the High Court on December 20th last year. We have made a detailed video on this development, the link to which has been given in the description box below. Please do check it out. CJI D.Y. Chandrachud has recused himself from hearing a contempt petition filed against comedian Kunal Kamra for his tweets about Supreme Court. CJI Chandrachud stated, and I quote here, "We will place this before a bench which I am not a part of because the comments were made on an order I passed. List after 2 weeks." Kamra had posted tweets against the Supreme Court of India following its order granting bail to Arnab Goswami. The Attorney General for India had found these tweets to be highly objectionable and had stated at that time that people understand that attacking the Supreme Court of India unjustifiedly and brazenly will attract punishment under the Contempt of Courts Act 1972. Responding to the proceedings, Kamra had submitted that his tweets were meant as a joke for people who shared the same perception as him. Today, the Supreme Court of India held that the parole period has to be excluded from the period of sentence under the Goa prison rules of 2006 while considering 14 years of imprisonment for premature release. A Supreme Court bench of Justices M.R. Shah and C.T. Ravikumar held that if the parole period is included as part of the sentence period, then any prisoner who is influential enough may get parole several times. This is against the purpose of actual imprisonment, the Supreme Court has stated. Today, the Supreme Court rejected the anticipatory bail application of a man who had 24 grams of heroin and brown sugar in possession with him. "This heroin and all is destroying the country. We cannot be a party to this," a division bench of Justices M.R. Shah and C.T. Ravikumar remarked when the matter came up for hearing today. The bench did not even budge when the advocate appearing for the petitioner pointed out that he had been in jail for about 9 to 10 months. The Supreme Court has held that non-banking finance and leasing companies are not liable to pay tax on the interest component included in the hire purchase installment paid under the hire purchase agreement. A Supreme Court bench of Justices Sanjeev Khanna and M.M. Sundaresh were considering the issue as to whether the appellants are liable to pay tax under the Interest Tax Act of 1974 on the interest component included in the hire purchase installments paid under the hire purchase agreement. The Supreme Court has given a simple and short definition for the term sufficient cause in Section 5 of the Limitation Act of 1963. Sufficient cause is the cause for which a party could not be blamed. Justice C.T. Ravikumar, who authored the judgment, observed. The Apex Court bench, also comprising of Justice Ajay Rastogi, was considering an appeal filed against an NCLT order dismissing an application seeking initiation of the corporate insolvency resolution process on the ground that it was barred by limitation. CGI D.Y. Chandrachud today remarked that balance in court was not always between just and unjust, but sometimes it was between two unjust things. He stated that in such cases the court had to determine what was more unjust. The remark was made in a dispute concerning appointments and promotion of assistant section officers. The matter was heard by a bench comprising CGI D.Y. Chandrachud and Justice P.S. Narasimha. In my experience, whenever there is a financial scam and the CBI or the ED come into the picture, there is a delay. It takes years together. You tell us in how many financial scam cases it has come to a logical end, demanded the Supreme Court verbatim today. The Supreme Court bench of Justices M.R. Shah and C.T. Ravikumar was hearing a PIL seeking a probe into the Orissa multi-crore chit fund scam, and the counsel for the CBI sought time to place on record the reply. Reportedly, the petition filed by Pinak Pani Mohanty stated that the chit fund scam that has hit the states of West Bengal, Tripura, Assam and Orissa involves collection of nearly 10,000 crore from the general public, especially the weaker sections of the society. The Delhi High Court today stayed the trial court proceedings against Bharatiya Janata Party leaders Hans Raj Hans and Majendra Singh Sirsa in a defamation case filed by Deputy Chief Minister Manish Sisodia. Justice Dinesh Kumar Sharma also issued notice on the petitions moved by the two BJP leaders challenging the trial court order dated November 28, 2019, summoning them in the matter. Both Sirsa and Hans, along with four other leaders namely Manoj Kumar Tiwari, Parvesh Sahib Singh Verma, Harish Khurana and Vijendra Gupta, were issued summons by an additional Chief Metropolitan Magistrate under Sections 500 read with Section 34 of the Indian Penal Code. The Madras High Court today rejected a plea by Thantai Periyar Dravidar Kazhagam challenging Governor R.N. Ravi's authority to continue to hold office. Holding the petition to be non-maintainable, the bench of Acting Chief Justice T. Raja and Justice D. Bharata Chakravarti observed that the court cannot issue notice to the governor as he enjoys immunity under Article 136 of the Constitution. The Karnataka High Court has called for changes in the nomenclature employed to refer to retired Army, Navy and Air Force personnel, suggesting the union and the state government to use the term ex-service personnel in place of the term ex-servicemen in its policy-making endeavours. A single bench of Justice M. Nagaprasanna of the High Court stated, and I quote here, there is an imperative need of change of nomenclature from ex-servicemen to ex-service personnel, which would be in tune with the ever-evolving dynamic tenets of Article 14 of the Constitution of India. The court stated that the word men in the title ex-servicemen portrayed discrimination as it sought to demonstrate that the forces were still a bastion of the male, which was clearly not the case anymore. Thank you. Keep watching Courts Today on LiveLaw for more such updates. See you tomorrow.